Think that what matters most to me as a fan is that the essence and the spirit of the people that I fell in love with are the people. Like, if the wall is green and lily blooms but our wall is purple, it doesn't really matter. Like, if I'm a book reader, it's that the people I fell in love with, that the stories I fell in love with, that the journeys I fell in love with, that grabbed my heart and soul, end up on screen. I really think that they
Welcome back to my channel. You know, a narcissist is involved when they keep filing motions in court, trying to paint the other side as dangerous, unhinged, and a threat to society. That's the image Blake Lively seems to want the world to have of Wayfarer. They're using motions and inflammatory language to control a narrative that they know will attract a lot of public attention. By sending these letter motions, they can get things in front of the judge more quickly than through traditional filings. I've never seen a case with so many letters and motions like this. The strategy is to portray Wayfarer and Justin as incredibly dangerous individuals, making it seem like there are serious threats involved, which discourages people from stepping in due to the backlash and the negative behavior online. Behavior that stems solely from Wayfarer, not from Blake or Ryan Reynolds. Now they're pushing for a multi-layered protective order, wanting only attorneys to access certain documents and confidential information. They believe that if Justin and his team discover the identities of certain individuals, those people could be in danger, which is absurd and just another tactic to manipulate the narrative and discredit Justin. Their team is opposing this type of protective order for good reason. Given how actively the Lively parties have publicized and litigated Miss Lively's claims in the media, it's surprising to learn how strongly she now wishes to keep certain material and relevant evidence from the public. The Lively parties provided the New York Times with Miss Lively's otherwise confidential administrative complaint filed with the California Civil Rights Department, along with thousands of pages of original documents, including text messages and emails. It seems contradictory that she wants everything to be private when she previously granted the New York Times access to all this information. Miss Lively's counsel and spokesperson have consistently tried to repair her damaged reputation with bold statements to the press, such as describing the Wayfarer Party's complaint as just another chapter in the abuse playbook, referencing Blake Lively's situation with Justin Baldoni's lawsuit. They also attempted to persuade the media that her amended complaint bolsters her claims by mentioning other supposed victims, yet she fails to name any of them. Outlets have pointed out that while Blake Lively's amended complaint alleges that Justin Baldoni made other women uncomfortable on set, she does not identify any of these women, and notably, no other women have come forward to sue him. If no other women are filing suit against him, then nothing they say will hold him liable. In a particularly troubling moment, during a planned skit on NBC's Saturday Night Live 50th anniversary special, which drew nearly 15 million viewers, Miss Lively's husband, Ryan Reynolds, made a joke about her claims of sexual harassment and emotional distress. In light of the order directing the parties to submit proposed protective orders, the Wayfarer parties have no objection to the entry of the court's model protective order. However, Lively's proposed protective order remains under consideration. Any protective order allowing for an attorney's eyes-only designation is not justified, even though the Lively parties argue that the ability to designate information as AEO is appropriate due to the workplace harassment claims involved in the litigation. Miss Lively has already made public the alleged details of the supposed harassment in her amended complaint, which spans 138 pages and nearly 500 paragraphs. Therefore, Miss Lively does not have a good faith belief that there is any information of such a personally sensitive nature that disclosing it would unnecessarily violate her privacy rights, as she has already outlined what she claims happened to her. There are corroborating witnesses and video evidence from these interactions or documents to support her case, making it difficult to argue that she now requires privacy. Furthermore, any legitimate concerns the parties may have regarding the disclosure of highly sensitive personal information can be managed through the procedures outlined in the court's model protective order. Essentially, they are arguing that she initiated this situation and put the information out there. They also point out that Ryan Reynolds, who is seeking a protective order, made a joke about the claims on a show which was unwise. I mentioned that they would bring this up in court. It seems they want full transparency, which I understand. If you have nothing to hide, then hide nothing. This group is asserting that they have nothing to conceal and are willing to disclose everything. On one hand, Miss Lively criticizes them for not providing her with their phone records, but on the other hand, when they refuse to share information unrelated to the case, she claims they are not being transparent. They are saying they want to show the evidence, but now that they have the chance to do so, they are hesitant. This highlights the contradictions often seen in narcissistic behavior during litigation. An attorney's eyes only designation isn't warranted here. This is a really unusual request, especially in high-profile cases involving public figures. I've been dealing with a similar designation for the past 3 years in a lawsuit filed against me by Robert Shin, the pastor featured in the Netflix docuseries, Dancing for the Devil, the 7M TikTok cult. I'm well acquainted with these attorney eyes only protective orders because we have one in our case. I understand the reasons behind such requests and how they framed me as a dangerous person, an existential threat, accusing me of doxing and harassment. I've experienced what Justin is going through. I know the feeling of being sued by a narcissist and being on the receiving end of a smear campaign. Narcissists often manipulate the litigation process, filing motions and making endless demands, creating a cycle of conflict. When it comes to discovery, they tend to withhold information, and even with a protective order in place, compliance is often lacking. The discovery phase will be challenging for them because, even if they get what they want, they'll find ways to avoid giving it. In my case, I hope for a summary judgment soon, but I'm uncertain if this case will reach that level or if it will settle. Right now, it seems neither side is inclined to settle. This situation is all about litigating in the press. They want to rehabilitate her reputation and create the illusion of a genuine threat with Wayfarer, but I just don't buy it. That's why they're trying to portray Steve as a threat. There's this guy going off about Israel and Hamas, claiming that the media is just trying to stir up fear about Wayfarer. It's clear that Miss Lively is not happy about her name being associated with this, and they filed a response this afternoon. It's unusual for motions and letters to be filed on the same day. It feels like a PR move to get their narrative out there. These letters read as if they're meant for the press, and they twist the words to fit their agenda. Remember the video we did a few days ago? I showed how Justin was discussing consent and his struggles with understanding it. Now they're using that against him. They're also taking relatively harmless statements from Rand Friedman and framing them as threats. They mentioned that the legal team for Wayfarer recently stated in a TMZ interview that neither Wayfarer, Justin, nor their representatives hold any ill will towards anyone who speaks out. They claim to understand the challenges of confronting powerful figures in the pursuit of truth. Essentially, they're saying they won't retaliate against anyone. The idea that Blake needs to make people anonymous is absurd because they have no intention of harming anyone. They're suggesting that the Wayfarer parties can help empower victims to stand up against powerful individuals by ensuring that their sensitive information is only accessible to attorneys who adhere to legal ethics. The defined specific and serious injury at stake justifies allowing both parties and third parties to initially rely on an AEO designation, while still permitting any party to contest such designations as proposed. They aim to protect these third parties, arguing that no one has come forward yet, and that the only way these individuals would participate in a lawsuit is if their identities remain confidential. However, that's not how lawsuits operate. You can't simply be a Jane Doe in situations like this. These are adults, not children, and if there were substantial claims to be made, they would have been brought forth already. The language used, such as defined specific serious injury, is absurd. They claim that those who might come forward would be standing against powerful individuals like those at Wayfarer. Additionally, they argue that Miss Lively does not genuinely believe there is any information that would infringe on her privacy rights, especially since she has filed a lawsuit outlining her alleged harassment. Miss Lively tried to address her concerns about an unsafe work environment directly with Mr. Malden, Mr. Heath, Wayfarer, and others before resorting to legal action, which only came after the defendants initiated a retaliatory smear campaign, as detailed in the amended complaint. It's important to recognize that they would not have pursued legal action if it weren't for this smear campaign angle. Their motivation for suing isn't solely about sexual harassment. They are primarily concerned with stopping the damage to their reputation which they believe is being caused by Wayfarer, though that may not be the case. This situation also reflects a troubling disregard and disrespect for a woman advocating for herself. The basic workplace protections against the Wayfarer party's interests highlight the futility of a future conferral. It doesn't discount the safety of women. Rather, it weaponizes the issue against them. The inevitable outcome of the Wayfarer position will be a significant waste of judicial resources as parties and potentially third parties attempt to convince the counsel for the Wayfarer parties that women do not forfeit all their privacy interests simply because they have spoken out or plan to speak out against them. Feels like they're just throwing ideas at a wall to see what sticks. It's a lot of word salad. Blake is already a public figure. She's made her arguments public. She even went to the New York Times. And now she's trying to act like she didn't start this fire that's been raging for a month. The argument seems tailored for a different audience. The Wayfarer parties begin their opposition by criticizing Miss Lively and Mr. Reynolds for seeking a protective order to keep certain documents and information private. They're openly bashing them in a letter to the court, showing just how sensitive Ryan and Blake are. This is their way of attacking Blake Lively regarding her request for a protective order. They express surprise that, given how actively the Lively parties have publicized and litigated Miss Lively's claims in the media, she now wants to prevent the public from accessing materials and evidence. That doesn't sound like an attack. It shows how sensitive they are to any criticism. This is what these individuals are facing. What I've noticed throughout all of this is that they aren't denying that she was the one who provided this information to the New York Times. Have you seen them deny any of this? Come out and spoken out? No, they said, oh, you can't penalize us for speaking out, you can't do that, so you're admitting you gave this to the New York Times, you're admitting that you did this publicly, you're not denying it, you're admitting it, which is weird because you denied it before. But what is most deranged and unhinged about this whole thing is that these types of motions are generally very boring and they're trying to make everything super salacious, which is wild too. Because a lot of this is just procedural stuff that shouldn't even be a headline because Blake and Ryan refuse to speak to the public, and when they do, they make jokes about it. They're using their lawyers to respond to the criticism they're getting, okay? And they're saying that they need to take advantage of these protective orders because certain online content creators who frequently parrot the Wayfarer Party line, at least one of whom happens to be a client of Wayfair's counsel Brian Fredman, who's pre-Hilton, has not said anything derogatory. Come on now, he does say that she's almost 40 and he calls her Blake, Scarlett Johansson's ex-husband's new wife. But that's also a fact, okay? But they have used similar misleading accusations, and this is the headline. Blake Lively asked a judge for a stronger protective order to keep Justin Baldoni's suit details private after receiving violent messages. That's actually what their request said. They mentioned that given the violent messages they were receiving, it was important for people to be protective. So I'm confused how that's the Wayfarer Party line when that's actually what their original request stated. Then they quote Candace Owens, who said they are really trying to keep some evidence out of the public eye. It would seem, are they not? And they also quote another tweet that says, late last night while we slept, Blake Lively and Ryan Reynolds filed a protective order. The guilty sin couple is asking a judge to protect from. The public has been exposed to some confidential documents and names collected during the discovery process. Candace believes they are guilty, which seems to pave the way for the fair counsel. It's absurd. Predictably, media outlets have picked up on this narrative, acting as if low-level influencers like Perez and Candace, along with anyone else who speaks out, are somehow swaying the Daily Mail and other major outlets to follow suit. This is ridiculous. Everyone involved in covering this case has a Pacer account and is reading the documents themselves, crafting headlines to attract clicks. It's Blake's side that employs inflammatory language, claiming she received violent threats and is seeking a protective order. None of this aligns with the Fair Counsel's official stance. One outlet claims Blake Lively is seeking a stronger protective order due to violent messages in the Justin Bond case. Her lawyer has argued that certain details should be restricted to attorneys' eyes only to limit the sensational headlines emerging from the case. The mischaracterizations embraced by the opposition, fueled by a manufactured echo chamber, provide ample justification for a protective order that ensures adequate protections for third-party privacy interests. Apparently, Perez Hilton and Candace believe they own the narrative, and any outlet that doesn't present a favorable headline and uses the language from their protective order is siding with Wayfarer. They seem to be realizing that their accusations of divisive language are backfiring, attempting to gaslight and redirect the conversation to suggest they are aligned with Wayfarer. Just to clarify, no one from FAIR has mentioned violent threats. They initiated this on the 20th and were the ones who brought up the threats. The court has good cause to adopt the proposed protective order without needing to speculate further. A clearly defined and serious injury is expected to occur in the proposed protective order because a specific and serious injury has already taken place, as detailed in her complaint. Her family, along with other cast members and various witnesses who have publicly supported Ms. Lively, have received violent, profane, sexist, and threatening communications. They are requesting a protective order citing these violent threats. Additionally, they mentioned that a family member of a witness received a threat indicating that they should be harmed unless the witness agreed to provide a statement and tell the truth. They also discussed how Ms. Lively's Instagram was targeted by trolls. They are the ones bringing up these threats. Yet they are now suggesting that content creators who discuss the violent threats mentioned in their documents are somehow affiliated with Wayfarer. This is a clear example of gaslighting, mind scrambling, and the use of confusing language along with projection and deflection. Various outlets are simply reporting what Blake Lively has requested from the court, and somehow if you mention that you are accused of supporting Wayfarer, it's frustrating to deal with this kind of manipulation. This is a classic tactic used in litigation with a narcissist. Furthermore, they admitted to leaking information to the New York Times, as they did not deny it when given the chance in their letter. Whatever happens with the protective order, it's not that serious. Most of us won't have access to much of the information in the lawsuit or the discovery process. It's really not a big deal. In my opinion, this seems like another attempt to portray Wayfarer as dangerous by linking vague communications they receive from likely internet trolls to the company. Victimizing Baldoni, and when Bond's team stated they wouldn't engage in the actions Blake is alleging, they twisted that narrative claiming, "Oh my gosh, see they're threatening people," which isn't accurate. You can't win against a narcissist. My main concern with this level of attorney's eyes only is that it allows any third party to request that their information be treated as such. If the opposing side objects, they have to take it to court. This can discourage some third parties from coming forward because if they do and their request is objected to by Wayfarer or Blake's side, they must go through the judge, which incurs additional costs. Every time there's an objection or a dispute over these protective orders, it leads to more court appearances and expenses. It's a tactic to control the situation and escalate litigation costs, which is why Wayfarer is labeling this as a frivolous lawsuit. They're accusing Wayfarer of trying to inflate costs, while the proposals on the table will likely deter people from stepping forward. If they object, they have to go to court, and these overly strict protective orders are incredibly frustrating. I know this from personal experience. What do you think about this? Share your thoughts in the comments below and don't forget to give this video a thumbs up. If you haven't subscribed yet, make sure to do so and click the bell so you never miss an update. Thanks for watching, everyone.